previous statement, the circuit, the juror not considered. May proceed, Mr. Bateman.
So I just want to remind us to please judge me on the facts and the evidence in this case. There's just not, you're not going to find evidence that I willingly, intentionally harmed these people, because I didn't harm them, and I didn't even have a desire to harm them. And in my mind, because I felt like I was a very good driver, I didn't feel like they were even endangered. And he mentioned that I was sitting in my real soft truck, but I would have easily got back there with them if I would have trusted somebody else to drive. But I like that kind of stuff. That's the kind of person I am. I like exciting things. Also, please realize that my decision-making abilities on this particular trip, more than probably my whole life long, were being taxed especially great after the silver saddle experience, because we saw that gentleman come up quite angry or quite bothered. And then it turned into exquisite pain and concern, and I freaking out when I got the phone call as I was pulling off onto the freeway. When they said our fingers are sticking out the door, I'm just like, oh my goodness. So I kind of freaked out. I think I pulled off right at that minute on the side on the, or at least as soon as I could, onto this median, or whatever you call it, emergency lane. And then that's about right when I saw, right as he pulled up to me, that's when I pulled off. He went ahead of me, parked on the other side of the exit. And I just got back on the road and pulled into the exit. So about half a mile from where I first pulled off to where I'd been stopped. Also, the other people may not have known my intention, but my intention was not to get on the freeway, because I understand the greatly increased danger with vehicles moving that fast and the big vehicles. I may not have told them that, but that was definitely my intention. And when I saw Ruth walking out of the trailer to get into the other vehicles, I just assumed that the others had done the same thing. I really don't have any worries about this, because if the truth were really known, you wouldn't convict me, because my intention is never to hurt anyone. I would humbly ask you to don't consider the what ifs in this circumstance. Because if we start getting into that, I don't think we'll ever end. That will ever end. Also, he mentioned that I rode in the trailer. You have to realize that most of the time when I stayed, we were in that trailer, it was just little teeny picnics and drives in the vicinity around my area, my town, or a house. Most of the time it was on dirt roads. If there ever was pavement, it was just around town and on very slow speed limited roads. And also realize that whole town is, whether the motorbike in this town you've ever seen in your entire life. There's more motorbikes going everywhere all day, pretty much. And so we kind of grew up in that kind of mindset. And I think I've already mentioned this, but I realized that when I exited the freeway after a mile or so, I was not nearly so concerned, because we slowed to much slower speeds. And that's why apparently it seems like it crossed all those turnoffs because it knows it's slow. And I was looking for something somewhere out of the way where it wasn't so much public. Because I don't know if you have the experience of being mocked by people because of the way you dress. It's not very fun. So we always like to feel when there's not a lot of people. Okay, some of you may wonder why I didn't cross-examine these female witnesses. And it's because I care about them beyond what I can really express. And I decided years ago that if it ever came to a trial, I would not ask them one question to make them feel uncomfortable, because I know it would. And I'm not sure what you're referring to about me saying extremely dangerous, but I don't think I ever said that, nor why I would never put anyone in an extremely dangerous condition, not even quote unquote an enemy. I would not do anything that I thought would harm them. And as we heard before from Brenda's testimony, I think there was ventilation in there. It may not have been a whole lot, but there was ventilation. I tried it when I hopped in there that time we were right in there. And also the door was partially secure, from which the latch showed. I don't know if you know much about trailers, but when it's latched on the bottom, you just about can't get it open. Brenda thought that they might have shook open, but sorry, it's going to have to go over a big, big bump to get that thing to come open. So if their body cam footage was accurate, was assume it was, that door was latched and the girls weren't really in any danger. They just might have seemed that way. And they said there's like a half-inch gap on the top where it's getting their fingers out. I don't know, I wasn't back there, but by all the videos and stuff, they had to open that door and latch it when they got there. So it didn't really appear, at least by the body cam footage, that it was extremely dangerous. Also realized that I was totally unaware that the door was open until I entered the freeway. Until I got off the country club drive onto the off-ramp, or the on-ramp, I guess you call it. That's when I realized that they were in there, and I panicked. I didn't drive for miles and miles and miles. I didn't want to harm them. It was not my intention, and it never will be. And frankly, you just can't prove that it is. My life can testify of it. I don't like harming anything or anybody. Perhaps what I did was reckless. I don't really have anything to say about that. It might have been a little reckless. But I don't do feel like it was dangerous or something. I felt like there was even a chance of something happening where they're going to be harmed. And I realized that there may not be a lot of faith these days, but I am and was a very prayerful person. So I ask God to bless us every time we do anything like that. We're going through these buddies or riding motorbikes or whatever. Also, it was mentioned several times by some of the witnesses that the Cameron Rapids were really bumpy. They're bumpy, but you just slow down. No big deal. It's just that little brakey thing, and it just slows right down. It's not a big deal. And as far as some of your questions about the disorganization of the trailer, I don't know if you ever asked children to organize stuff like that, but sometimes don't get organized very much. So I don't think that was that disorganized because of, I'm sure there was some shaking around the course, but I don't think it was because of stuff falling over. And one last thing, I did not use the restroom. I just did not use the restroom. That's just not what I do. Why would I use the restroom where they can smell that trash and fumigate the whole inside of the trailer? So I'm not sure where somebody remembered that, but that did not happen. And that concludes my remarks. I would just humbly ask you to consider the facts and consider my intent the best you can, and judge me not guilty. And just my humble prayer. Thank you.
Thank you, Mr. Bateman. Thank you. Please be seated. The record will reflect the presence of the jury at this time. At this time, has the jury reached a verdict?
Yes, we have, Your Honor.
All right. And if you'll please hand the verdict forms to the bailiff. Arlene, if you'll bring those up to Jan. And the clerk will now read and record the verdict.
Your Honor, may I omit the captions?
You may.
Thank you. We, the jury, duly impaneled and sworn in the above entitled action and upon our oaths, do find the defendant, Samuel Rapidly Bateman, guilty of the charge of child abuse in relation to Shirley Baseline, as set forth in count 1 of the indictment. We further find count 1 to be a dangerous offense involving the use of a dangerous instrument proven beyond a reasonable doubt. Signed by juror number 3, foreperson. We, the jury, duly impaneled and sworn in the above entitled action and upon our oaths, do find the defendant, Samuel Rapidly Bateman, guilty of the charge of child abuse in relation to Gladys Johnson, as set forth in count 2 of the indictment. We further find count 2 to be a dangerous offense involving the use of a dangerous instrument proven beyond a reasonable doubt, signed by juror number 3, the foreperson. We, the jury, duly impaneled and sworn in the above entitled action and upon our oaths, do find the defendant, Samuel Rapidly Bateman, guilty of the charge of child abuse in relation to Dorothea Barlow, as set forth in count 3 of the indictment. We further find count 3 to be a dangerous offense involving the use of a dangerous instrument proven beyond a reasonable doubt. Signed by juror foreperson, juror number 3.
All right, thank you, Joe.
Members of the jury, are these your true and correct verdicts?
Yes.
And at this time, does either party wish to poll the jurors?
No, Your Honor.
All right, thank you. Members of the jury, on behalf of all the participants in the trial, I want to thank all of you for your service this week and before this week, doing the survey monkey and everything in advance of the trial. We truly, truly appreciate all the efforts that you've made. So on behalf of everyone in our county, I thank you. The admonition is now lifted. So at this time, you're free to talk about the case with anyone or not talk about the case if you don't wish to. It's entirely up to you. If someone asks you about the case and you don't want to talk about it, just please advise them of that fact and hopefully they'll honor that request, but you have no requirement to discuss the case. Please do leave with us your juror badges and your notebooks. We'll destroy your notes, but the badges and notebooks we reuse in other cases. Once again, your jury service is now completed and you are excused. members have left the courtroom. At this time, the court is going to revoke the defendant's release conditions pursuant to Rule 7.2. Mr. Bateman will be held without bond pending sentencing. At this time, the court also is going to set the matter for sentencing hearing. If Mr. Bateman would be willing to waive time beyond the usual 30 days, I could do an off-calendar setting for him on August 11th at 2:30.
Your Honor, can I just explain?
Go ahead.
And Judge, if I may, both myself and Mr. Piper are available that day. Is there a time the following week that would work?
Mary, could you come in with the calendar? I know it's going to get a little tricky. Okay, we've got it. I know we have 2 trials during the month of August so far.
The next available date would be August 25th at 2:30.
That does work for the state, Your Honor?
Yes, I'm okay with waiving time.
All right, what would the time be again?
At 2:30.
At 2:30 also. Can I ask, Ms. Breskas, can you ask would that date be suitable for the victims? All right, I appreciate that. With that input from the victims and both of the parties and Mr. Bateman's willingness to waive time beyond the usual 30 days, the court will set the matter for sentencing on August 25th at 2:30 p.m. A pre-sentencing report is ordered. The court generally orders people to cooperate in the preparation of a pre-sentencing report. Mr. Bateman, however, you may wish to confer with Mr. Hartman-Strong as to the level of participation that you wish to engage in preparation of pre-sentencing report. I'll leave it at that. Is there anything further from either counsel?
No, Your Honor.
Thank you.
Your Honor, I just want to put on the record, Mr. Bateman and I just got confirmed on that. I'll be out of the country that week. However, Mr. Bateman is okay with a different advisory counsel from out of standing as a substitute.
All right, thank you. Is that correct, Mr. Bateman?
Yes. Mm-hmm.
All right. At this time, we are adjourned. Thank you.